So good morning, everyone. Before we start this webinar, please note that this webinar will be recorded. So if you do not want to appear on the recording, please turn off your camera as well as your microphone. So welcome to our webinar, which is Legal Proceeding, General Condition and Insolvencies under the Dutch and the French perspective, and it is provided to you by the French desk of Bierens Law and as well of the French Chamber of Commerce. So Bierens Law is an international law firm that deals with everything entrepreneurs have to deal with, such as entrepreneurs, litigation, screening, drafting, contracts, general terms and conditions, bankruptcies. They have several desks, Spanish, German, I am very sorry. They have several desks, Spanish, German, Polish, French, and in the French desk, they help Dutch clients who have business in France and the other way around as well, French companies doing business here. Today, our speakers are, I am sorry, my kid is sick and I do apologize.
No problem.
It's really sorry. So today's our speaker are Keisha Dirlik. She's an attorney at law and she specializes in international disputes, contract law, distribution, and agencies. I am truly sorry. This is really unprofessional and I do apologize. I will
no problem.
Keep introducing the two others speakers, and for everyone and the speakers, truly my apologies. So our first speaker, as I said, is Keisha Dirlik. She's an attorney at law. She specializes in international dispute, contract law, and distribution and agencies. Our other speaker is Anneke Zandvoort. She's as well an attorney at law, and she specializes in insolvencies, law, in international dispute. And our last speaker is Manon Rurman, and she's a trainee lawyer at the Pays-Bas School. There will be three parts in this webinar, and you can ask questions after each part. So you will be able to ask questions in the chat or by unmuting yourself after each part. I let you to our experts, and I truly apologize, but that's a nice way to start the morning. Life is the way it is, but have a good webinar.
Okay, thank you for the introduction. I will start with imagine that you are a Dutch company in flower bulbs, and you have sold flower bulbs to a French company. And you are trying to limit your risks by using general terms and conditions. But what are actually the rules for using general terms and conditions in the Netherlands? And what are the rules in France? And which rules should you follow? And in a case of a dispute, is it more favorable for you to litigate in the Netherlands or in France? And what if a customer finally goes bankrupt? What can you expect in a bankruptcy in the Netherlands? And what is the difference between a bankruptcy in France? And lastly, we zoom in on the possibilities to retrieve your belongings in the event of a bankruptcy in the Netherlands and in France. My name is Keisha Dirlik, like Noemi just said. Welcome to this webinar, Legal Proceedings, General Terms and Conditions and Insolvencies. In the next hour, Manon, Hanneke and I will take you into these three subjects and zooming in on the differences between the Netherlands and France. This is the agenda for today. First, we will discuss the terms and conditions, then the legal proceedings, and then the insolvencies. First of all, we will have a poll. I will first explain some things. Once again, an example of the Dutch flower bulb company. From the Dutch flower bulb company, you have been in contact with a company in France, and that company was interested for buying 100,000 flower bulbs. You have drawn up an agreement in which, among other things, reference is made to the general terms and conditions. And the general terms and conditions have been sent with the agreement by email to the French company. In the agreement is written that half of the purchase price must be paid down and the other half must be paid after delivery. Well, the French buyer has paid half of the purchase price. So the contract has been concluded, but the only question is, do the terms and conditions apply? What do you think, yes or no? Now you see the poll on the screen. Maybe you can all choose what you think. No problem if it's not right, not at all.
The polls are anonymous, so anyway, you can give your answer.
Do we see afterwards a percentage of the answers?
Yes, we will. I will launch the result afterwards. We're still waiting for a few people to answer.
Okay, now nice to see that almost everybody is going for the same answer. We will come to this answer a little bit later on. First, we will take you to the rules in Netherlands for using general terms and conditions, and then the rules in France. Yeah, so what are general terms and conditions? General terms and conditions are, as the word says it a little bit already, general agreements. General terms and conditions contain general rights and obligations of your clients. And by using general terms and conditions, the agreements that you enter with your clients become less extensive. After all, you include the general agreements in the terms and conditions. Well, the general terms and conditions are often used to limit a company's risk. Among other things, it's possible to make agreements in case a client does not pay, or about the place or country where a procedure should be conducted, and also under which law. And in the same condition, you can also agree on a retention on title in order to be able to retrieve the goods in the event of a bankruptcy. Yes, so the next is how do you apply the general terms and conditions correctly according to the Dutch law? Well, the first step is to declare the general terms and conditions applicable. The terms apply quickly. According to Dutch law, it's only needed to refer correctly to the general terms and conditions in the agreement or in the offer. In practice, we see many references that are incorrect. So in the next slide, I will show you an example of how you can refer correct to the terms and conditions. So the general terms and conditions of Lentebloemen BV version 2020 apply to this agreement. The general terms and conditions are attached to this agreement and available at, and then a hyperlink of the website where the concrete link of the terms and conditions. And then by accepting this agreement, the client states that he has read, understood, and accepted the content of general terms and conditions of Lentebloemen BV version 2020. After this presentation, we will send a PowerPoint to you. So if you want to look again how it's written, you can check it then. Now the question is, one back. Well, the second step is the acceptance. It works just as with agreements. General terms and conditions must be accepted. And according to Dutch law, this acceptance can take place explicitly but also tacitly. So explicitly means, for example, that your client signs the terms and conditions for acceptance, and tacit means, for example, that the terms and conditions are mentioned in the agreement or in the offer, and the other party does not protest against the applicability of the general terms and conditions. And then the duty to inform. It's also important that the user of the terms and condition provide information about the terms and condition. The user must provide the buyer a reasonable opportunity to take notes of the general terms and condition. In practice, this means that the terms and condition must be handed over or sent, and this has to be done or at the conclusion of the agreement or before, but not later. So sending the terms and conditions together with the invoice, that's too late. And then the proof, if there will be a discussion about are the general terms and conditions handed over, is somebody informed about the terms and conditions, then the user of the terms and conditions is responsible for proving that they have been actually handed over. And you can prove this, for example, by having the other party sign for the receipt of a copy of the general terms and conditions, or if you're doing electronic business, by email in which you send the agreement or offer and terms and conditions, that email can be the proof as well. And then for service providers applies that it's enough if they have in their agreement a concrete reference to the conditions on their website, so they don't have to hand over the terms and conditions. And then, yeah, what happens if you don't inform? The consequence is that your counterparty can destroy the terms and conditions. So then you can't rely on the terms and conditions at all anymore. The handling requirement does not apply for larger companies. So there are companies that are 50 employees or more, or they have published annual accounts. If you're doing business with these big counterparties, then it's enough to refer to the terms and conditions, and then it's up to them, to the big counterparty, to find out which terms and conditions are concerned. Of course, if they ask for sending them, you have to send them. So I go to the next one. Yes, so what are the subjects that you can arrange in the terms and conditions? Like, there are a lot of subjects, but these are a couple ones. The competent court, the applicable law, the interest. In the Netherlands, it's common in business-to-business relationship to have an interest, to ask for an interest between 1 and 1.5% per month. The debt collection costs, that's up to 15% of the outstanding amount. Then the retention of title, of course, limitation of liability, force majeure. There are a couple things that are important to think about when you're writing terms and conditions or checking the terms and conditions. So we were talking about agreeing which court has jurisdiction in the general terms and condition, but what can be benefits of doing this? Benefit can be the distance, because you can choose a court that is located close to your company or at least in your own country. You can litigate in your own language. That's often much easier for yourself. The cost can be lower in your own country, or at least you don't have to make big costs for traveling. You can have more clarity about the duration of a proceedings. And then an important last thing, the interpretation, because the judge in your own country will interpret your own law probably correctly. But if you're doing international business and you don't agree in advance on where to conduct the proceedings, you may also have to conduct proceedings in a foreign country, although the law of your country could apply. And in that case, the foreign court will have to apply a law that is not its own law, and that increase risk of mistakes in interpretation. So that's not a desirable situation. and then the applicable law. Benefits of putting something about the applicable law in the terms and conditions is that you may have knowledge about your own law, or it's easier for yourself to receive some knowledge about your own law. And of course, also interpretation. The judge of your own country will interpret your own law correct, probably correct. So that, and then we come to the French parts.
Thank you, Kasia. So yeah, let's start with French now. As you will see, is a bit different than Dutch in the Netherlands. However, it is still a unilateral contract that is established by the seller to regulate contractual relationship. Here, I will focus mainly also on business to business. Indeed, if you are the buyer and you would if you would do business with a consumer, another set of rules will apply. Keep that in mind, that are way stricter. So for business to business, it is provided in the French Commercial Code, in the article L444-1 of the French Commercial Code. And as I told you, rules are different with the consumer because it is considered as a fragile party, a party that the law wishes to protect. So if the client is a consumer, no questions are asked here. You need to have terms and conditions. I won't dwell so much on it. It's provided in article L111-1 of the Code de la Consommation. And you also have some sets of clause that needs to be in there. And then I will move to the next slide. Now is how to make sure that you can rely on it. So now for business to business, which is our main subject. So the good and the bad news is there are no form required by law. Why is it a good news? It's because, well, you don't have a specific set of exact contract that you can use, meaning that you can also make it more suitable for your business, and you can also discuss it with your seller, with your buyer and your seller. The bad news is it gets a bit confusing because then what do you put in it? When should you send it, etc.? A lot of question arises from that. What we know for sure is that verbal information is not sufficient. The French jurisprudence is very clear about that. I see we have a question. I will address it right away. Can terms and conditions for French client be written in English? So I will just see that a bit later. But the rule is, if you are doing international business and if the English language is understood by that buyer, for example, yes, it can be written in English. Just make sure if you put two languages, for example, you draft them in French and in English, just make sure that in the terms and condition, you provide which language should be superior to the other. Meaning if there is a conflict between the two languages, we all know that sometimes a word in French cannot really have the same in English. Just be sure that you choose one language that will apply over the other one. So either French or English, just make sure. That's quite important. Also, take into consideration whether or not you have a contract with your buyer. Indeed, terms and conditions will be even more important if you do not have a contract with your buyer, because then nothing will be provided. So you have to be very careful that everything you want to be in there is in your terms and conditions if you do not have a contract. Of course, if you do have a contract, things will be provided in there, some clause that will put a bit less pressure on the terms and conditions, but that does not mean that you should not have any terms and conditions. As for Dutch law, it is the same in French law. You have to make sure that they are known by the debtor before the sale itself, meaning do not put the terms and conditions in the back of the invoice 30 days after the delivery. This is not going to work, okay? I hope everything is clear. Now let's go to the next slide. Okay, so the communication of the terms and condition, which is a bit tricky. If you can take one thing from this webinar, is that the general terms and conditions need to be accepted by your buyer, debtor, whomever, who you are in contractual relation with. This is the safest option for you. Have them sign by your buyer, your debtor, whoever. It's quite important, because if you do this, then no question will be asked. If you don't, I am not telling you that it won't apply, but it's going to be a bit more difficult. Indeed, the French jurisprudence is assessing whether or not it could apply. So there are some exceptions. For example, if you have been in a long commercial relationship with your buyer, then the pressure reduces. For example, the judges could say, okay, the terms and conditions apply because they have not been changed since, I don't know, last year that you have done a lot of business with that buyer. And you have done it for a couple of years, and you know each other, and you already were aware of the terms and conditions. But if you have them substantially changed, they need to be accepted again. So if there is any problem with the applicability, meaning your buyer is saying, no, I've never known those, I don't know what your terms and conditions are, the burden of proof rests on the party claiming the opposability of the terms and condition. So if you are the seller, then the burden of proof rests on you. In France, what we do use quite a lot is what we call a constat d'huissier, which is a bailiff report that will basically go to your website and go through each step of the acceptance of the terms and conditions, maybe through a website, for example, it could be. Whether or not you had to tick a box, etc. And basically the bailiff is going to take screenshots of each step to prove the judge, to explain how those terms and conditions were acknowledged and accepted by the debtor or not. Another thing, it could also be by registered post. As in France, it's something that is used a lot. Lettre recommandée avec accusé de réception, meaning that your buyer will have to go to the post to retrieve them and sign. A bit old style, but it's a good way to prove if you have the paper saying that your buyer has retrieved them. Okay, let's go to the next one. I will do a slide focused on something that happened a lot, especially lately with the COVID situation. A lot of maybe your buyer have not paid the invoices. As Cassia told you, you can, in your terms and conditions, provide for an interest that will apply for the late payment, and also collection cost. So if you have to call Bierens someday, or to call a collection agency to recover the debt that someone has over you, then you can provide that in the terms and conditions. However, if you don't, there is still a net under you, meaning that in France, the commercial code provides that there is a debt collection cost that will be paid of 40 euros per invoice. Keep that in mind, because it can make a big difference. If you have one invoice with a very high amount, this is going to be 40 euros. But if you have several invoices, so I do understand it is more complicated to do so also for the buyer. It's not as easy as to have one invoice, but the rule is 40 euros per invoice. This is for the collection cost, and then you have the penalty for a late payment, which is the interest rate. So if it's not mentioned, you will have the European Central Bank interest rate. It has been very low lately, between 0 to 0.25 plus 10 points. So in practice, basically you will have a 10% annual rate if you have a French buyer or debtor. Okay, I think we can move forward. So a bit of an overview of what we just said. So for the Netherlands, as you saw, it's basically easier. The applicability is easier, Kasia, right?
Yes, it is easy to make the general terms and conditions applicable. It's easy for acceptance, like I said, can be explicitly, can be also tacitly. But there is a main rule. It has to be, you have to inform your counterparty before or at the moment of closing the agreement. So not later than that. And of course, according to Dutch law, there are some exceptions as well in case of a long-term business relationship, things like that. But these are the main rules for if you're doing business with a counterparty for the first time.
So yeah, proof, that's what we said in France, proof of knowledge and accepted of the general terms and condition, it's required. Just make sure that you have them signed. It could be more, of course, time consuming, but it can save you a lot of money or a lot of hassle, especially in those COVID-19 with the force majeure, for example. A good French idea, not only good wine, that's the good news. It can be implicit in some way if there is a long-term business relationship, etc. And then also same as in the Netherlands before the agreement, and stricter condition for applicability, and the assessment is made usually by the courts in France. So the answer that I guess I've been bothering you. So we are returned to the case of the Dutch flower bulb company, because flower market is very big in the Netherlands. So yeah, as we told you, the company has sent an agreement by email with the general terms and conditions that were attached in the email. The agreement states that half of the price must be paid down and the other half paid after delivery, which is something that a lot of companies do. So the French buyer has paid half the price. The question was, do the terms and conditions apply? So most of you have the Dutch perspective. As we just told you, under Dutch law, it is sufficient in the if the terms and conditions are tacitly accepted, because the French buyer has paid half of the purchased price. So according to Dutch law, the general terms and conditions apply. However, under French law, it's a bit more complicated, unfortunately. The main rule would not, the condition would not apply, at least not automatically, meaning that you're going to have to prove, meaning time, money, to prove through a bailiff report, etc., that they have been accepted. So the best way would have them signed. I'm really insisting. But now I hope you all follow, because it's going to get a bit more complicated. Because it is an international agreement, since it is between two different countries. So the question now, under which law do you determine whether or not the condition apply? So you determine in the basis of the Vienna Sales Convention. I'm going to go quite quickly, but just have that in mind if you do international business. So the Vienna Convention on Contract for the International Sales of Goods is a treaty that automatically applies to international contract for the sale of movable property for the countries that have signed it. Quite some countries have signed it. 85 countries are member of it, almost all European member states, and also countries such as the USA, Brazil, China. So because the case therefore involves an international contract for the sale of movable property, you must determine, in accordance with the Vienna Convention, whether the general terms and conditions of the Dutch flower company apply. So even if the applicability of the Vienna Convention is excluded in the terms and conditions, you must use the Vienna Convention rule to determine whether or not the terms and conditions apply. It's a lot of international private law trick, but I hope you still follow. So what does the Vienna Convention requires is that the terms and conditions are included in a contract where the parties have explicitly or implicitly agreed to general terms and conditions, and the other party has had a reasonable opportunity to take note of the terms and conditions. So let's take some example here. What's a reasonable chance? So for example, if you attach a document or print it at the back of a contract, if the terms and conditions were available at the time of the contract, at the time the contract was negotiated, for example, or that the parties have previously contracted together with the same terms and conditions, as we already discussed. So to conclude, if you therefore have an international sale, it is advisable to apply both your own national rule and the rules of the Vienna Sales and Convention for the use of the general terms and conditions. So make sure that you mention that in your terms and conditions, in the contract / offer, and that the document is attached. I will not dive very much in the European directive that will apply if nothing is provided between two European member states. But just have that in mind in case. And then a battle of form. Again, I won't go too deep, but let's imagine that you have some terms and conditions and that your buyer also have some. Who wins? Very quick overview. In the Netherlands, it's the last shot rule, meaning that the last person who have sent the terms and conditions will be the winner. And in France, it's the knockout rule, meaning that they both cancel themselves.
Yes, I want to add something to that. It's the last shot rule, but it's not enough just to send as last person or last party the terms and conditions. You have to say expressly, I received your terms and conditions, but I don't agree with those. Here are mine, and I want to do business on my terms and conditions. So if you don't say that, you just send your terms and conditions, that's not enough.
Okay, so you must form a kind of counter offer, am I right?
Yeah.
Okay, good, thank you.
Okay, I'll go ahead because I will share my own presentation. Now, I lost the meeting. Which screen do you see? Not on your
your
we see
presentation.
procedures Netherlands.
Okay, then it's fine.
Okay.
Okay, but then we first have a sheet before, and that is the poll. The question is, it's the same Dutch flower bulk company as Kasia told us about, and the company has a dispute with a French company. Where do you think that the court fees are lowest? Is it the Netherlands or is it in France? Do we have the answer, Sylvie? 73% of you thinks it's in France and 27% thinks it's in the Netherlands. Well, we come back to the answer later on. I will first tell you something about the procedures in the Netherlands, and I'll focus only on the main procedures that we have and that we actually use for business-to-business disputes. So then the main procedures are these three. The subpoena procedure, which is called in Dutch dagvaardingsprocedure, of course the seizure, beslag, and the bankruptcy procedure, that's the faillissementsaanvragen. Of course, there are a lot of differences between how procedures run in the Netherlands and in France. And actually, during this Corona period, it turned out that the differences are even bigger. So in the Netherlands, well, procedures kept running by written procedures or video conferencing. In France, actually, courts closed, and there is now, well, a layover of 15 months. Even Corona didn't take 15 months so far, but so that's why it can be attractive to also choosing your terms and conditions for a specific court, because now we know that in the Netherlands you actually can rely on the fact that if you start a procedure, it runs well on time. Is perhaps too optimistic, but it still keeps running. For the dagvaardingsprocedure, the subpoena procedure, you have a little control via your terms and conditions, as you can choose for a specific court and specific applicable law. It has to be written in the contract, so it's a bit harder to make sure that you choose it than terms and conditions only. So then make sure that they are signed or write them in the normal agreement. The court fees in the Netherlands vary, and what is mentioned here is the court fees from 2021 onwards, as there is a big change coming up then. Then there's also the possibility of seizure. For example, if I know that I have a claim on my debtor and I know that he has a bank account where will be money, I can seize the bank account. There's partially control via terms and conditions, as the court that is competent in the main procedure can also be competent for the seizure. But if I know, for example, that Manon has a property in France, then it's not possible to seize that via the Dutch court. The court fees for seizure are always the same, no matter how high the claim is, where for the subpoena procedure, it depends on the height of the claim and the court that you have, how high the court fees are. And then one of the, quite specific procedures in the Netherlands is that you can request for the bankruptcy of your debtor if he's not paying. And it's called the faillissementsaanvrage. And also then the court fees are only €656 and are always the same, no matter how high the claim is. There is even though no control via terms and conditions, as that would make it more attractive for people to switch or choose for a court that is perhaps easier. So it's by law declared that the competent court is the court where the debtor is seated. And that was actually so far. Then a small note about the cost of the procedure, as the question was about it. In the Netherlands, of course, for the procedure, you make cost for your lawyer, for the court fees, for the bailiff, what's to hand over the writ. And those court fees and the bailiff costs are an actual compensation. So if you made, for example, €656 for the court and 400 for the bailiff, and you were right, then the debtor has to pay both the 656 and the 400. But if you spend like €10,000 on your lawyer, this will definitely not be paid. But it's just a fixed fee, and that depends on the height of the claim and how many actions you have taken. So, for example, there is a compensation for the writ, for an oral hearing, and in the Netherlands, it depends on the court. The court can decide. So, if I start a procedure, I start with the subpoena. If Pasha is my counterparty, she can react on that, and then the court can choose, okay, do we do another written round or do we do an oral hearing? If it comes to an oral hearing, both the parties and their lawyers are heard. So usually the court will ask questions to the client for just the facts, when did things went, was it blue, was it red? That kind of questions, and lawyers actually on an oral hearing have just a small part, because they should have written everything already. So it's just more to make sure that everything is said than that it's really new facts from the side of the lawyer. So the court actually chooses if it's written or an oral round. And that's actually it for the Dutch procedures.
Thank you, Anneke. Can you go one before? Yeah, thank you. Okay, so the procedure in France. So the main procedure that you can think about are the one there. So the order of payment, which is basically a form sent to the court to recover the money that is owed to you. It's very quick, that's the good news. However, if your debtor disputes, and it's also very easy for your debtor to dispute, meaning he just also has to fill in a form, then it goes to the proceeding of the merit, and it's not as easy. Then the fast track procedure, which we call référé provision, which is also fast track, a bit less than the order of payment, especially as Anneke has mentioned, French courts are behind. I've even heard trade unions from lawyers saying that it was up to 18 months of delay. So yeah, keep that in mind and be patient. So that référé provision, it can only work if your what you claim is not disputed heavily. Both parties will have their say, but if it's not contested, it will not go to the procedure on the merits. If it is, it will. The procedure of the merits is really the basic long procedure, where there is a calendar put in place, where both parties send submission. For example, company X will send submission on the 10th of December, and company Y will answer to those submission on the 10th of January. So it's very, it can be quite long, and after those exchanges, it goes to a special judge that will decide if the case is ready or not. Juge de la mise en état, if that can be of any help. And then we also have a summons for bankruptcy proceedings, assignation en redressement ou en liquidation judiciaire. In this case, it's usually that you have tried something else, meaning that you have tried a procedure on the merits, and you have tried to execute that decision. And for example, there is no assets to seize, or the bailiff cannot find all the bank accounts are empty, they're closed. So what you could resort to is a summon for bankruptcy proceeding, and it will also go in front of a judge. And same, you cannot provide for any court competent in your terms and condition. It will open, the procedure will be opened in the where the company is registered. So if it is registered in Paris, then the procedure will be opened in Paris. Now with the next slide concerning the cost. So well done everyone who said France. But not so much, because the compensation of procedural cost is less in France than in the Netherlands. We have what we call Article 700. It's an article in the Civil Procedure Code that allows the judge to decide freely how much money should the losing party pay to the winning one. Since you are winning, you are in your right, and you should not have to pay the lawyer cost and any costs that have been involved. For really disputed case, it can be quite symbolic, so quite disappointing for you. Disappointing, I'm gonna manage. It's more made to compensate lawyer fees, usually between 1,500 to 2,500, which when you think of a procedure could be insufficient if you have had a lot of lawyer fee, also bailiff involved. It can be not sufficient. And then we have what we call the dépens. Dépens is only the cost paid to the court. This is the good news. In France, it's almost free to start a judicial procedure, meaning the costs vary between 30 euros, 80 euros, or 100, depending on the procedure. So for example, in the procedure that I presented you, the first one, the order of payment, this is 35 euro 21 cents. So it is quite cheap and almost free in France to start a procedure, but you're not compensated as much. So the comparison, the Netherlands are oral or in writing. Tell me, Anneke, if I say anything that isn't right. The lawyers and party are heard both during the hearings, much higher court fees. That still could look reasonable if you look from a perspective, a US perspective, etc. It could still be reasonable. In France, the procedure is oral. However, keep in mind that it's becoming less and less oral. Unfortunately, it's a big it's a point of pressure here, and with the COVID even more, since the tribunals are so busy, the oral procedure will be way quicker, and you won't have the big pleading as you can see on TV shows. It will be only observations by the lawyer. There is a court hearing for every step. Doesn't mean that there is a pleading for every step, but at least the lawyer will have to go to the court at each step. Only the lawyers are heard by the court, not the parties. Yeah, it's just the lawyer represents the party, so he will basically bear their voice and make their voice heard. And there is almost no court fees. Something also interesting maybe to know for France is that the Tribunal de Commerce, so the commercial tribunal, it's not professional judges that are here, meaning that it's business people. Which makes a difference as when you go to a civil court, tribunal judiciaire, it's professional judges. So it just keep that in mind, and they might have a different perspective, a more business-like perspective, which can be an asset or not, depending on your situation.
The answer of the poll has been already, it was France.
Yeah, it was France. Not much suspense, but it can be also. But maybe if you see the compensation, you have to maybe make a calculation, right?
Mm-hmm. And then we go ahead with the insolvency, another poll. If you have unpaid invoices and after 3 months you find out that the person to whom you have delivered is declared bankrupt, so the bankruptcy is 3 months old, are you still in time to lodge your claim? Sophie, do we have the answers?
Yeah, there's still people answering, so I'm
okay.
just gonna wait and then I'm gonna launch it.
Quite equal, 50-50. Well, that's a nice answer, interesting, and we will come back to the answer later on. So in the Netherlands, we have actually 3 types of insolvencies. We have the bankruptcy, we have the WSNP, which is for consumers, and we have the surcharge van betaling. The first 2 are actually the people are sort of bankrupt, and the last one, surcharge, actually same as in France, is just it's not that they're bankrupt, but they're trying to solve their financial problems to prevent a bankruptcy. But in the Netherlands, actually, most of the time, the surcharge ends in bankruptcy. Publication of bankruptcies in the Netherlands is via this link that is mentioned on the sheet. And actually, it's the day after it's already published. So lots of companies have a link to that, so they know the day after that their counterparty is declared bankrupt, as it is quite important for your business, of course, not delivering goods anymore to a party that's declared bankrupt. You have to lodge your claim at the liquidator, and the terms in the Netherlands are actually, well, there are none. Just make sure that you lodge your claim before the end of the bankruptcy to be in time. But if you're a normal creditor, and I will come back to which type of creditors you have, in 96% of the cases, in 96% of the bankruptcies, you will not receive any money of your claim. So, well, if you will not be in time, which will actually never happen, well, it's not a big problem because you would have received nothing anyway. So then here are mentioned the 3 types actually of the creditors. So the first ones are the boedelschuldeises, the estate creditors that are the highest in rank. Then the second one are the preferente schuldeisers, the preferred creditors, so they're second in rank. And then all the others, so usually all the people who delivered goods, are the concurrente schuldeisers, so the competitive creditors. So you see already mentioned that the boedelschuldeises are receivables after bankruptcy. So for example, the cost of the liquidator, but also if the liquidator thinks, okay, it's needed that we do this during the bankruptcy, then these are codes that are also receivables after bankruptcy. Then the preferred creditors, they're based on statutory rules of priority. For example, tax authorities, salary of the person who worked, that kind of creditors. And then we have the competitive creditors, who are, as mentioned, suppliers of goods, services, prepaid funds, and the bank, as long as they don't have a secured claim, so no mortgage or no pledge. Then what if the supplier or customer goes almost bankrupt? Can you find an alternative supplier? Does it have any financial consequences? There are some things that you can arrange contractual. So for example, an insolvency clause. And I have to say that it doesn't always work, but an insolvency clause, for example, that you say that when the other party goes bankrupt, then I don't have to deliver, I can end the contract, and I don't have to pay for new, let's say, kind of party offers your clients, and then you don't have to pay for the clients anymore. Then there's also the possibility of a damage clause, but of course that won't work that well in an insolvency. I mean, you can hire your claim, but the fact is that the counterparty has no money, so you can, for example, you have a lease contract and you say, okay, as soon as the counterparty goes bankrupt, then I can end the contract, and instead of the terms that had to be paid already, so like for the last months that have been passed, I can also ask for the terms that would come up till the end of the contract. So for example, the next 2 years. Then you have a claim which is way higher, but the counterparty still is bankrupt. So, for example, instead of a claim of 2,000 euros, you now have a claim of 20,000 euros, but it's still a competitive creditor who has to hand in their claim. More attractive are guarantees. So if you have, for example, a bank guarantee, because the bank guarantee also works in case of a bankruptcy. Besides that, of course, you have the personal guarantee or the group guarantee. So, for example, if you have a group of companies, then the mother company will say, okay, if my daughter company, which you did business with, doesn't pay the claim, I will. That's, of course, way more worth it than only one person who pays for it. Then we have a collateral clause. That's, for example, pledge and mortgage. But it's not really common for normal creditors to achieve this. What's also attractive is, some rules in your contracts and contractual options to unbind and pick up the goods in case of a bankruptcy. I will come to that in the next sheet. Because an interesting option is the retention of title. That means that the owner will be owner till full payment. Therefore, actually, you need an action in terms and conditions. It's a contractual agreement, and you have to do it in advance. So before the delivery, you have to make sure that you have in your terms and conditions or in your agreement that you deliver under retention of title. As Kasia told, it's quite important that the general terms and conditions are applicable and not destructible. And I have to say that it only works for delivered goods. So if you delivered, for example, wood, then it works for the wood, as long as it's still there. If the counterparty used it to make cupboards of it, then it's not your wood anymore, so you can't get it back. Now we have two options for the delivered goods. We have a limited retention of title and an extended retention of title. The limited is that, for example, you have invoice A and it's for 100 euros. And you also have invoice B, C, D for, let's say, even 100 euros. And if invoice A is unpaid, then you can only get the goods back that were delivered under invoice A. So, for example, the counterparty sold all the goods under A, but the goods of B and C, all that invoices are still there. Then you can't claim those back because you have a limited retention of title. Therefore, the extended one is more attractive because then you can say, okay, I delivered goods, it was for an amount of, and then you can take up all the invoices together. And I delivered those goods, and you can also take all the invoices together. So if the counterparty has, let's say, left unpaid 10,000 euros, then you can just get your goods back for an amount of 10,000 euros, no matter on which invoice they were mentioned. Then we have, according to Dutch law, also have a non-contractual option. That's called recht van reclame. It's sort of the same as the retention of title, but as it's based on the law, it's of course quite strict. So it has to be invoices that are not older than 60 days. And you have to do it within 6 weeks after the deadline of payment. The problem is that in lots of bankruptcies, well, there are invoices that are left and paid for a way longer time, and then it doesn't work. So that's why it's quite important and well, mostly attractive to make sure that you deliver a retention of title, because then you don't have any term binding.
So, friends, I'm just going to touch quickly on the little comments that were written. So given the waiting time, it is true, but keep in mind that not all procedures will be delayed by 18 months. For example, we've had cases where we did order of payment, the first procedure, very cheap one. This one, for example, we've already had a decision. So, for example, a month later. So even with the delay of COVID, etc., it really depends on the procedure, on the tribunals also. Some tribunals might be more busy than others. So it don't take, as a rule, 18 months away. Okay, just think it depends on the tribunals. And for fast track procedure, etc., it will be quicker and it won't take 18 months. And then the role of a client in a procedure in France, it's a very good question. The client is a bit withdrawn in a French procedure, meaning he's not even expected to be there at the hearing. And if he is, he's going to be sitting in the back. So just, it's different than from the Netherlands, and no questions will be asked. We're really talking about commercial law. Of course, in other procedures like criminal law, etc., it's different, and usually we have that idea in mind. But no, the client is very withdrawn and more passive, and all the communication will be with the lawyer before and also maybe during the hearing, etc. So yeah, I hope that answered the question. So insolvencies in France, the type of procedure we also have three. Procédure de sauvegarde judiciaire, which is where a company is not in bankruptcy yet, but wishes to prevent further debts, meaning it's not doing great and it wants to survive and keep the payment going. But the goal really is to save the company as much as possible. The procédure de redressement judiciaire, here the company is in bankruptcy, the situation is worse than for sauvegarde, but wishes to set up a payment plan with the creditor in order to survive. The bad news is the plan can take up to 10 years. Not always, again, it's just up to 10 years. As you see, a lot of things are quite slow. Sometimes it's shorter if the creditor accepts to reduce their claim, but it depends on how many debts there are and how bad the situation is for the company. And then you have the procédure de liquidation judiciaire, which is basically the worst for the company. The company is bankrupt and will not continue its activity. Everything is done to pay as much of the debt as possible before dissolving the company. Where is published the bankruptcy? It's on the website that's just written there, BODAC, annonce list. So in the BODAC, you have, it's available for everyone, and if you have the registration number of the company, you just put it where it's supposed to be, RCS in France, and you can see if the company has been bankrupt, etc., or if it has, I don't know, put the annual accounts online. So now what do you do if your customer goes bankrupt? It's quite scary, but the thing to hang on to is the publication of the bankruptcy on that website, because this date is important. The date of the publication is important. I will just go on that after that. In France, something that can be a bit different than from other legal systems is that the debtor is forbidden to pay any debt dating before the opening of the bankruptcy proceeding. In that case, it's not that he does want to, he does not want to, it's he can't. It's the law, it's the article L622.7 of the French Commercial Code. So what you do if your consumer go bankrupt is you have to register the claim. So when the procedure is open, a curator, I was going to say it in Dutch, a curator is placed there, and the conversation, the discussion will be with him. So you have to register the claim, ask your lawyer to register the claim within 2 months of the date of the publication of the bankruptcy, so of the procedure. If you are a French company, so if you are a French company and you do business with a French company, you have 2 months. However, if you are a Dutch company, for example, or Belgium, Spanish, whatever, then you double that time. So 4 months for a company that is established outside France. You have longer, of course. Quick COVID updates, those delays have been frozen. A lot of delays have been frozen between March and the end of June in France. But now, unfortunately, we are basically out of that delay. So any statutory limitation that would stop within that period was extended. But we are too late for at least the registration of the claim. So keep in mind that website, BODAC, and register the claim basically as soon as possible, and within 4 months. There is a possibility to ask the curator to lift that limitation, but again, it's not ideal, and the best would be to do it within the time limit. Oh, let's go to the next. Thank you. We also have an order for the creditors. So the creditors with a retention of title are the first one. So we come back here to the first part of the terms and condition and why it would be very interesting to put a retention of title clause in your terms and condition, for example. We will go again to the retention of title just after that slide. Then the second will be the creditors prior to the opening of the insolvency proceeding, and then the last one will be the creditor post opening of the insolvency proceeding. So it's, if you start doing business with someone, maybe it's nice to check on the website if it's published or not. So the retention of title, what we call clause de réserve de propriété. Why would it be relevant? So as I told you, the debtor is forbidden to pay. However, that this does not apply to the retention of title, because the retention of title can lead to a right of réclamation ou réclamation, a droit de revendication. It's quite strict, however, how you can rely on it. The clause needs to be agreed by both parties in writing. There is no maneuver possible here. It needs to be agreed in writing and at the latest during the delivery of the good. This is provided in the French Commercial Code. This clause can be in the terms and condition, as we've discussed before, but then really keep in mind that then they also need to be in writing and signed. Okay, so there is no maneuver if you have a retention of title clause. And they also need to be sufficiently obvious. I guess that you have heard about some litigation where little tiny letters were written at the back and of the contract, so to make sure that everyone knows. And as a principle of transparency of commercial relationship, it's important that this clause is sufficiently obvious. So the term of action, again, it's quite short. The creditor has 3 months to act from the publication in the BODAC. So again, the website, this date, as I told you, is quite important and make a lot of delay and limitation start. You also do it to the curator, just like the registration of the claim. If you fail to meet the deadline, then you have an inopposability of the right of revendication to the insolvency proceeding. It's quite strict, and the Cour de Cassation, the highest court in France, has been quite strict about that. After the request is sent to the curator, if it's done within the time limit of 3 months, then the curator has 1 month to send his answer to you or your lawyer. If he does not answer for XY reason, or if he refuses, then the creditor, so you as the creditor or your lawyer, of course, will have 1 month to ask the judge to decide whether or not this clause applies. Thank you. So yeah, as I told you, the conditions are quite also strict in France. The publication of the judgment takes on average 15 days. It can be shorter or it can be longer, but I know some other European countries like Spain, for example, it can take up to a month to be published. The delays are very strict, and how much time can you expect is between 6 to 18 months in the case of a liquidation. But of course, redressement, which is the one in the middle, the plan can take up to 10 years.
Yeah, and that is different in the Netherlands compared to France. It's also, we have a nice, I think, example, because Justin had a procedure running in France, and the French court did not believe that the Dutch party went from, well, let's say the 1st of December is surseance van betaling to a bankruptcy the week after. So I had to explain that in the Netherlands, well, there are no binding terms that the surseance takes place for a specific term, that it can be actually only days, and that the bankruptcy can take up to years.
So now the answer of the poll. Do you want to take on, Anneke, or should I?
Yes, that's fine. That was actually, everything was good, because compared to French law, then, well, there were specific terms. So you were not on time, and according to Dutch law, you were on time. So actually both answers were good. I don't know if you have any questions on any of the topics.
I don't see any questions, but maybe you want to take and unmute yourself if one of the people in the audience still has a question they would like to address directly to our speakers, then you still can.
So it's not usual that the client is being heard by the judge in France.
It is unusual that the client is heard by the judge in France. The rule is that the lawyer will be heard, but the client, as I told you, he's not even expected to be there at the hearing.
Okay. And I was traveling to France this week.
Okay. Sorry, I didn't hear. You are traveling to France?
Yes. Is
Yeah?
it easy or is it difficult?
To travel there?
With the COVID arrangement.
Well, it's going to ease down a little bit in the 15th of December, but now it's still quite a strict rule, meaning restaurants and bars are still closed, but the borders have not closed. So if you have a reason, it's perfect. Just don't forget to print and sign the international paper to enter France. And I think everything should be okay. Just don't forget that.
Okay, thank you.
Of course.
If there are no further questions, I would like to thank our speakers, Hanneke Zandvoort, Kasia Duurlik, and Manon Roggeman. Thank you so much for sharing your expertise with us. It's such a relevant topic. It's always a relevant topic when you're doing business, and it's more than relevant for our French-Dutch business community, who of course work a lot between the two countries. So it's always good to have more insight on what is applicable and why. So thank you so much for sharing your expertise with us. We will post a replay on the website with their presentation. So if you would like to share it with colleagues or others, you can. Thank you very much and have a nice day.
Thank you.
all for your time.
Sure.
Thank you.
Thank you.
Goodbye.
Goodbye.
Bye.